Well, another drama is playing out between the police and Parliament. This is not the first time this has happened, at least in the last 1 year or so, plus, because we've seen this before. This time, it's played out in the full glare of the public and has left two entrenched positions. The police are determined to bring Francis Sosu, Xavier Sosu, who's the MP for Medina, to justice, as they believe he may be involved in some unlawful acts during a protest in his constituency. Parliament says, listen, you need to do so respecting the constitutional provisions surrounding inviting a member of Parliament. But within the same context of that protest, 3 people have already been arrested. So why not the member of Parliament? Many of you have asked the question, are MPs above the law? The members of Parliament say, we are certainly not above the law, simply follow procedure. So if that is the case, why this tussle? Let's go through where we are tonight as far as this unfolding drama is concerned. It has to do with this man. He's a member of Parliament for Medina. And the CID had demanded his release. They've written to the Speaker of Parliament asking that he be released. Why? Because they were investigating alleged unlawful blockade of a road during the protest and the destruction of public property in his constituency during that particular protest that he led. And I'm sure you've seen that video has emerged today in which he was speaking to some constituents. We'll get into that very shortly. So Parliament responds to the police and say, we're sorry, we cannot release him to you. But the Speaker gave a few reasons. His fundamental reason is this. It has to do with Articles 117 and 118 of the 1992 Constitution. Because of these two provisions, he says, I cannot release him to you. We'll get into what these two says very shortly as this begins to still play out in the public domain. The police have responded in clear terms to this. It says that it will deploy, in spite of what the Speaker had said, will deploy every legal means to interrogate the MP for Medina on the matter. They want to question him. They say they've invited him once and he's turned them down. Indeed, they make that point here. They decline an invitation, the police claims, to attend on them on this particular matter. Again, turned down a further invitation citing parliamentary privileges, which the Speaker himself has also cited, as I pointed out. Well, the police denied the claims that it had deployed a team to arrest him in a church. You saw this play out on Sunday. We've seen various positions on this. The police had said the men they sent there were to gather intelligence. The member of Parliament in a statement today said that can't be true. They were there to arrest me. Although the Speaker had been very clear on what procedure to follow. Now, the police also say 3 other persons have already been arrested on this. But the key question to ask is, if 3 people have been arrested and the police really want the member of Parliament, can they also go ahead and do so without the drama that is unfolding? Well, there are rules governing this if the person is a member of Parliament. And the question that rises is, did the police follow the procedure as specified in the Constitution and elaborated upon in the standing orders to do this? Well, this is not the first time I said this happened. Under the last leader of Parliament, the Speaker, Michael Quay, this also became an issue, this time not only between the police and Parliament, but between the court and Parliament. It forced a High Court judge to actually call the bluff of the Speaker to say they do not answer to the Parliament when it comes to the way it does its job. Isn't it time for this to be settled? As we've seen, the police say they are actually intending on going to the Supreme Court for an interpretation on this. We've seen a few key individuals also speak about this, notably the Interior Minister, who's spoken about this to our sister station, Asempa, and had said the MPs are not above the law. The MP says, yes, we are not above the law, but he believes, if you listen to him, his argument is, also because this matter has now been referred to the Privileges Committee. Why? Because the Speaker of Parliament believes those 2 police officers who had attempted to arrest Sosu at the rally violated his privileges, and they have now been referred to the Privileges Committee. The Interior Minister believes MPs aren't above the law and that equality before the law, make yourself available for interrogation. we've had a few legal, I guess, opinions on this, and the lawyers disagree, right? No two lawyers on this matter seem to have the same position. Kofi Abuchi says the police are not duty bound to inform or seek the permission of the speaker before effecting an arrest. So as far as it's concerned, the police could have, on that day, simply arrested the MP and they would not have violated any procedure. The speaker disagrees because those two officers who attempted to arrest Osu had been referred to the Privileges Committee because he believes his privilege was violated. We've spoken to the chairman of that committee who said they're going to look into this. If you also speak to Mami Fua Adajikum, she says Parliament to provide clarification on this matter. But is it Parliament that should do this? Or is the, as you call it, the Supreme Court? They are, of course, for the reserve to interpret this because the law itself is clear. And these three elements here are always subject to some interpretation. So you cannot serve a civil or criminal summons on a speaker, a member of parliament or clerk, if he is on his way to parliament, he is attending to parliament or returning from parliament. Some have said returning from, he's done with his job. Why can't a police effect a lawful arrest? This is the particular clause here in the Constitution that has become very thorny in the last few days. Civil, or again, it says no civil or criminal process coming from a court or place out of parliament shall not be served on or executed in relation to the speaker or a member of the clerk to the parliament while he is on his way to, attending or returning from any proceedings of parliament. How do you interpret this? It's become one of the biggest conundrums, which is causing all this back and forth. We're going to get into this again on the back of what has happened today and look forward to how this can be settled once and for all. Stay with me on PM Express. And joining me right now to have this conversation, we have Martin Bebu. He is a legal practitioner. Also joining me is Mahama Yariga. He's a member of the Constitution Legal Affairs Committee in Parliament. He's also MP for Boko Central. We'll be joined shortly by Yao Pon. He's also a private legal practitioner on this. I want to start with you, Mr. Yariga, because I recall very correctly that you were also caught in the same soup, if you may, if my memory serves me, just a little over a year ago, when the special prosecutor had attempted to prosecute you. Michael Quay gave a reasoned decision, actually wrote to the court. It became a back and forth. It's playing itself out again. What's your own reading of what is happening now?
Thank you very much for the opportunity to join this discussion. I think that the context was a little different in the sense that in my case it had to do with an attempt to serve a court summons on me whilst I was in Parliament, and that was the basis of the protest. So the context is a bit different. In this instance, I think we're dealing with two situations where there was an attempt to arrest me at a public demonstration, and then another attempt on a Sunday when the member of parliament was in church. So that's the little difference in the context. But the principles are quite clear and simple. And the language of the Constitution is not too difficult to comprehend. It's simply that, one, you cannot be served with summons when you are on your way to Parliament, you are attending at Parliament, or you are on your way from Parliament. That was quite simple. The question then is, if it's a day, if you try to serve anything on a member of Parliament, you can simply tell that he's on Parliament. Try to serve with him in the day, towards evening, he can simply tell that he's on his way back from Parliament. So it's not that safe to try to serve any such thing or get an arrest with a member of Parliament on a day that Parliament is in session. You may have to trail the person till the person gets home at midnight before you will try to serve the summons or track the arrest. It's different. The role of the speaker comes because very often then the police will write to the speaker. And in my case, the special prosecutor wrote to the speaker. And I had an issue with that because my position was that the right of a member to be able to attend Parliament without being hindered by way of summons or arrest is a right conferred on the Member of Parliament. It's not a right that the Speaker can waive. So you cannot write to the Speaker and ask the Speaker to waive that Member of Parliament so that you can serve the summons on the Member of Parliament. And so I took a position that it wasn't within the competence of the Speaker to either waive, the immunity or refuse to waive the immunity. So my position on that still stands.
And it's interesting. It's interesting, Mr. Ayega, that you make that point, because even in the current case, we've had many of your members, and in fact, the current speaker also believe that the police somehow need to get the speaker's permission. In fact, they had written to the speaker asking him to release the MP. Where from that practice? Is it written in your parliamentary standards that regulates the House?
I think what happened was that the police and the courts tried to find a middle way around how to get a member of Parliament to answer, because we don't want to take a position that parliamentarians are above the law and therefore, cannot be, summoned to court or cannot be arrested or cannot be held liable for whatever offense they may commit. And yet the Constitution also clothes parliamentarians with a certain level of protection for very good reason. And so I think over the years, they resorted to approaching the Speaker and engaging with the Speaker and getting the Speaker to then come to an understanding with the police, where, let's say, police CID will come to Parliament, the Speaker will summon the parliamentarian that they want to interrogate to his office and create a space there, and then they will interrogate the parliamentarian, sometimes actually take a statement from the parliamentarian, so that it is not presented as if parliamentarians are above the law, and etc. There are several instances. I have actually, been interrogated in the Speaker's office by CID, and I gave a statement in the Speaker's office, signed it, and the CID took it back to their headquarters. And I know about 20 other parliamentarians that went through that process. So the perception out there that, parliamentarians don't want to subject themselves. No, when you engage the Speaker, what it is that you want to do, what issue you are investigating, the charges involved, the Speaker will usually just arrange for the MP to come to his office and for the CID to come there. Then they have access to the MP. They can ask all the questions. They can ask for a statement, and the MP will normally write the statement for them. All he will do is to request that his lawyer should be present at the meeting. So that perception out there that we play above the law, it's not true. We always subject ourselves. It is when, the perception is that we are just engaged in political witch hunting or something that is irrelevant. Like in this instance where it was a demonstration, and from all the facts that we have, he had written to the police about the demonstration, and etc. And I listened carefully to the police. And this time I hear them say, we're not arresting him, we're asking him to come and help us in an investigation. Come on, which law says that I'm obliged to come and help you in an investigation? Which law? Tell me which law in this country says that I'm obliged to come and help you in an investigation. And if I don't come and help you in an investigation, which is your job anyway, I should be held responsible. So if they really have a good case and they approach the Speaker, normally he will arrange for the MP to come and the CID to also come, then they can meet. And then whatever question for the MP will be asked. And if they want a statement from the MP will give the statement. And I'm saying this from personal experience because I have so many members of Parliament being interrogated in the Speaker's office by CID in the presence of their lawyers. And at the end of the day, They said they asked for statements, and the statements were written for them by the MPs who were being investigated. So we're not above the law. We don't play above the law.
Yeah, I mean,
So,
stay with me, Mr. Ega, because I want to bring you your of course, legal practitioner, Martin Kpibu, on this. Martin, before we even get to details, I just want a quick comment on this practice. Mr. Ega had just explained that practice of writing to the speaker, it's just a way of, trying to abide by the constitution, respect it as it relates to how to deal with an MP when you have a criminal or civil procedure to serve on him. What do you make of that practice?
Yeah, so, well, it's because the practice is sanctioned by law. That's we are talking about the Parliament Act 300.
Okay.
Specifically, Section 20 makes. Let me refer to it. Section 20, subsection 2. Okay, it makes provision that even though there is a general provision that a process may not be served on a member of parliament and all that, but when it comes to the criminal matters, you can apply. And when you apply, the speaker may grant. So 22 says the speaker, on an application being made in that behalf, may direct that paragraph A of.
We'll take a break. When we return, we'll get the details on this practice. As you learn, it is actually written in law. Stay with me. You're still live on PM Express. My guest still with me via Zoom, Mahama Yariga, who is a member of Parliament for Boku Central. He's also a member of the Constitutional Legal Affairs Committee in Parliament. And we also have lawyer Martin Kpibu, who, of course, was talking to us. Unfortunately, the connections weren't great. Hopefully, we can have a good line to him now. Mr. Kpibu, you were actually stating that practice where the speaker is written to, asking for his permission, is written in law. Hello, Mr. Kpibu. Okay. Do we have Ms. Ayarga on? Okay, Ms. Ayarga, you're still with me?
yes, thank you.
Okay, great. So let's come back to the specifics of this case as we have it. Today, we know that the police have said that they are still determined. In essence, the member of parliament is still a wanted man. They've written to the speaker. The speaker says no. And they insist that they'll go the full length, including the Supreme Court, for an interpretation on this. When you hear people say that parliamentarians are acting as if they are above the law, your reaction to them is what?
This is unfortunate, and it won't be good for us to allow that to be created, because in this instance, so far I've heard the police say that they are trying to effect an arrest. So far I've not heard that, because
okay, we seem to still have a challenge with him. Do we have Martin?
Yeah, Evans.
Yes. Okay, Martin. Yes. Thank you. We lost Mahama Yariga. Guess where we got you. So let me come back to the point that
establishing a crime.
Okay.
A summons. So I'm really confused, because I think the police themselves perhaps don't know what they are doing, because you hear them in one breath saying, oh, we're asking him to come and assist us in an investigation. And the other breath, the impression I get is that they are trying to effect an arrest. And
okay, let's try and rectify his line. Let's bring him Martin.
that is where I have a problem.
Mr. Ayariga, please hold on for me.
Please.
Hold on for me. Let's see if we can get a better connection to you, because we're struggling to hear. Mr. Kpibu, you were detailing the law that spells out the process of writing to the speaker to get his permission. Hello, Mr. Kwebu. Okay, well, today we had a video image, and you can watch it on my JoyOnline.com on this particular matter, which is the latest on this, and some members of parliament also defending him. But this video, you see the member of parliament in question addressing some of his constituents ahead of that particular protest. I wanted to watch this and tell me what you make of it.
Listen to what I am saying. On the 25th, there will be a demonstration for the roads to be fixed. I will be the one to lead this demonstration. It will cover the whole area. We will block the roads for them to know that we are serious.
Okay, so that's the member of parliament there, just before the protest, and you see him there in that conversation with his constituents, and he was speaking in Cree to them, talking about listen to what I'm saying. We are doing a demonstration for this road to be fixed. He says on the 25th, I will personally lead this demonstration for the road to be fixed. I mean the whole area, the road shall be blocked. He says. Then, of course, the few of the people there, one of them says no car should move. He says the MP then responds, of course, so they know that we are serious. That is what I mean. His spokesperson today had said that when he says the road shall be blocked, he was talking about road blocked by the movement of the people, the sheer movement of people at the protest, and not through unlawful means, which is his interpretation to this. I still have Mama Yariga with me. He's joined us on phone, hopefully. Mr. Yariga, just before you come in, so this video had circulated today, and we understand that the police actually has this video as one of the things they are looking at. The police, in their statement, said the reason why they were looking for the member of parliament was for alleged unlawful, they're investigating alleged unlawful blockade of roads and destruction of public property. This video circulates today, which we understand the police have a copy of and they're using as a basis for the investigations, in which the MP talks about leading the protest and that the roads will be blocked. His spokesperson, I must add, has said that when he said that, what he meant was that the road will be blocked with the people as they demonstrate, not what we actually saw on the ground. When you play that against what we've heard, shouldn't the MP avail himself to the police, so at least his side of the story will be heard?
You see, what people forget is that there is a right not to self-incriminate. So your right not to self-incriminate, it says that you can't compel the MP to come and tell you things. You should go ahead with your investigation. If the videotape is enough to establish your case against the member of parliament, you can run to court and start it from there. The MP can come and decide that he's not going to say anything. He can say, I can come, but I'm not going to say anything. If you have decided that you have a good case enough, you want to go to court, you can go ahead and go to court. So the impression being created that everybody has a responsibility to come and talk to the police is actually wrong. You can go to the police and decide that you are not going to talk, and they cannot compel you to talk or give a statement. You are not compelled. You can just say, look, I have a right to remain silent, and I'm going to maintain my right to remain silent. Go ahead with the investigation for other pieces of evidence. And if you satisfy yourself that you have a case, go to court. So I don't think that the MP is obliged to go and give any statement to anybody. If they have that case and it is enough to establish a case against him, they can go to court. If they go to court, then they can get a court order. And now they would have to serve a court order on the member of parliament.
As far as the Public Order Act is concerned, The police say there were unlawful blockade of the road and alleged destruction of public property. And seeing that the MP led the protest, for the Public Order Act, if something goes wrong during the protest, isn't the police obliged to, arrest or if indeed want to proceed, hold the organizers or the leaders responsible, in which case the MP becomes a person of interest?
That's entirely a matter for the police to decide, the investigators to decide. It is not for the MP to help them to carry out that exercise. The impression that the MP must come and help them to carry out that exercise is where I have a problem. I'm not disputing the right of the police to carry out their investigation. I mean, they can go to his house and ask him questions. He can decide that he won't answer. They can meet him anywhere to ask him questions. He can decide that he won't answer. They can actually write to the speaker that they want to meet the MP in the speaker's office to ask him a few questions. I'm not sure the speaker will deny them that. And I'm saying that I have personally, on several occasions, been asked to come to the speaker's office and to be interrogated there and then give a statement to the police there. And it has happened. So I think the problem is where the police themselves are approaching their work. The MP can refuse to speak to the police on grounds that speaking to them may incriminate him. And the right not to self-incriminate is guaranteed under the Constitution. So let's get that straight. If they have the tape, and if they think the tape is enough to found the charges against the MP, they reserve the right to decide what they want to do with it. But subjecting all of us to this, public discussion, creating the impression that MPs, are trying to live above the law and all that, I think it's not fair to us.
Okay, thankfully Martin Kpebu is back. Martin, you were explaining the position of the law when it comes to this practice of writing to the speaker.
Yes. So, Evans, the law permits that under Section 20 of the Parliament Act 1965, Act 300, specifically Section 22, that the police or any other investigating institution may apply to the speaker, and it is up to the speaker to grant a waiver. That is to say, the speaker will say, okay, I'm releasing the MP to attend upon the police or EOCO or DNI or any other investigating institution. Okay, and releasing the MP, as Honorable Ayaga is shown, is not always necessarily or not necessarily the case that the MP would go to the police station or DNI, but sometimes it can be done on the precincts of Parliament, like the examples in which the speaker released his conference room for the interrogation and all that. Yes. So, we've used this provision over all these decades. Okay. So quite clearly, I'm not sure why the impression is being created that the MPs are portraying themselves above the law. So, sometimes some citizens may make certain statements, but there are no facts to back them. And so it's up to us to use the record to show that that statement is not true, because at least, so it's even good you have Honorable Ayaga on the program. He was interrogated, he stood trial in the court of law, and eventually was acquitted. There are other cases. You remember Abu Dhabi? Yeah, Abu Dhabi was tried, he was found guilty, convicted. I remember Abu Dhabi, you see? Yes, and then I'm watching, he was taken out of Ghana. So you see that the list still has some people in there. So we should not give currency to the statement that the MPs are portraying themselves above the law. It's just a procedure that has to be followed.
I mean, so why has it always caused so much controversy, this particular clause in the Constitution, which has always been used and has become such a contentious matter?
Sometimes I believe it's the media reportage as well. Sometimes media, you guys need to constantly inform citizens. And you see, as soon as you put the camera on people,
sometimes they become zealous and actually sometimes become overzealous because, the camera is watching. So it's like the whole of Ghana is watching. So then the officer tries to do his best. And then in the process, he may be overzealous and fall foul of the law. I think that, in the management, there's this theory. When somebody is doing something in private, the energy levels and the rest are usually different from when you put the camera on him or when people are watching. So when people are watching, there is that innate desire to do it extremely well, efficiently, very fast and all that. And then in the process, the person can fall foul of the law. Because from day one, when the speaker issued the letter that he wasn't ready to release Honorable Susu, I thought the next step would have been that perhaps then they would have engaged him privately to find out when he would be willing to. Because, the speaker himself is an astute lawyer. He didn't seek to say that he would never release Honorable Susu. So he should have been in negotiation about when the speaker will be ready to release him. So that attempt to arrest him on Sunday was poor judgment. Yeah, it was extremely poor. The way they besieged the church premises is bad. Subsequently, you hear the Public Relations Officer of the Police Service, ACP, You see later I say it was a tactical withdrawal. This tactical withdrawal, this is about the second or third time I've heard it when there is such an embarrassment. Maybe next time they should just go a bit more cautiously. Once the speaker had said he was not going to release Honorable Susu, the next thing should have been, okay, so when should we come back to this? And in Ghana, there is no limitation of action. Let's use a very popular case. You see the case of Honorable J.B. Tankwa. The case is still ongoing. Okay? There are many other cases. Yes. All right? Yes. In another conversation, we'll complain that the case takes too long. But right now, the illustration I'm making is that we are fortunate in Ghana, there is no limitation of this action when it comes to the criminal cases. So sometimes we'll ask our friends, the police, whom we need very, very, very much to in the democracy to keep the law and order, to also be a bit circumspect. We need the MP to do their jobs well, and we need the police to keep us safe. So we need both, and they should collaborate.
Let me ask you this. When I read that Article 117, there's a part that makes me wonder why the framers of the Constitution put it in there. I mean, where it says civil or criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member of Parliament or collective Parliament and this is the part, while he is on his way to, attending at, or returning from. I mean, the returning from, why can't the process be served on a Speaker, member of Parliament or clerk when he's done with his job and he's on his way from Parliament? What could possibly be the rationale for that?
Yes, so my understanding is that usually, this is to make sure that they get the best of attention for the job. The best of the attention.
No, but I'm talking about the returning from. He's done with the job. He's returning from the Parliament. So he's finished with the job.
So, Evans, when a member is returning from Parliament, we would not know what brief he has to go home and continue with the work. Usually people take a lot of work home, assignments and the rest. We would not know. So that's how come, and I'm happy you're mentioning it. Of course, we also see that we need law enforcement to work. That's how come, you remember, Ace and Kuma has said that the police should go to court, and the police are lacing their boots. I've heard from reliable sources. And now I've seen on the media that they are lacing their boots. So let's see how it pans out in the Supreme Court. So we would look at the jurisprudence in the UK, US, other countries, and then the Supreme Court will look at it and strike a balance.
Okay. There's some specific aspect of this. Mr. Ayaga, you were in Parliament when the Speaker indeed referred the two senior police officers who had attempted to arrest Sosu to the Privileges Committee. Why? What's the reason for that? Why the two officers and not the IGP or the Interior Minister, in whose name they were acting?
Well, I mean, they were the ones who actually, according to the Member of Parliament, tried to arrest him and obstructed him. So I think that is the basis on which the Speaker would have referred them to the Privileges Committee. The issue of contempt is not institutional. It's not institutional. So it is not the case that because they are pleased, then it is the institution of the police service that should be referred to the Privileges Committee. It is personal. So you obstructed a Member of Parliament or you breached the privilege of a Member of Parliament. So you are the one that will be referred to the Privileges Committee. So I don't think that there's an issue. But your earlier question about why a Member of Parliament returning from Parliament,
yes, Parliament, yes,
the protection.
Yeah.
Well, I mean, the premise of the Constitution, and I think those who are conversant with parliamentary democracy understand that the whole idea behind the privileges is to protect the Member of Parliament to be able to perform his job. Let's say that you allow the Member of Parliament to be picked up just when he's leaving Parliament. Because Parliament is the sitting is public, a Member of Parliament who doesn't want to make he or herself amenable to being served will just avoid sitting because he knows that if he gets to Parliament, they will know that he's physically here. So they will just ambush him, and immediately he steps out of Parliament on his way home, they will serve him with the summons. So I think it's a comprehensive regime to protect the Member of Parliament. That is why I disagree with the position that you could actually write to the Speaker and then the Speaker can exercise a power to waive the immunity. I disagree entirely with the law, and I said this in the case of Michael Quay and in my own case, because my contention is that this is a protection that is given to the Member of Parliament personally, as a Member of Parliament. And it is not, a protection that can be waived by anybody. It cannot be waived by anybody. It cannot be waived by the Speaker. It cannot be waived by the courts. It cannot be waived by everybody, by anybody. So the position that you can even write to the Speaker and then the Speaker will waive the immunity constitutionally granted, and read the clause, the article. The article does not subject the grant of that immunity to any other condition. So you can't have a law that says, the Speaker can, on a case-by-case basis, waive the immunity. But I'm saying that some of us have subjected ourselves to the practice because we also don't want to create an impression to the public that we are running away from justice. And so when you approach us respectfully, we will also respond respectfully. We will come. After all, the police service is our police service. The courts are our courts. So why not? Let's go. If you have a case against me, let's go, and then I will answer. If you really have something you're investigating, just come. We can discuss it. Even in my office, I've had special prosecutor staff, Yoko staff, actually, come to my office in Parliament, and I granted them audience, and they interrogated me in my office, and I didn't even tell anybody that Yoko was in my office. I didn't object. I can give you the names of the Yoko staff that came to my office about 2 or 3 years, 4 or 5 years ago, 3 years ago. So we do that. But the way you approach the MP or the way you approach the Speaker will determine how he will respond to you. So if the police think that an MP has done something wrong, and it is a time when Parliament is in session, and they don't try to reach out to the Speaker to say, look, this your MP has done this, we're investigating this matter, and want to talk to him. The Speaker will call the MP and say, look, the police say you have done this, they want to talk. Are you open to sit with them and talk? The MP invariably will say yes. Speaker will say, okay, come to my office. They will come there. They will ask all the questions they want to ask. And that can constitute the investigation. And if they think that they have established a good case, they can, decide that they want to prosecute. But if you decide to go and obstruct him on the way and, try to show that you have powers, definitely the MPs will also raise the issue of their immunity, and they will stand by the immunity and fight it in court. I think that is all that we are seeing. It's not about MP not wanting to engage the police.
I mean, Martin, let me ask you this hypothetical situation, but it could be true. So a police officer comes across a member of parliament actually in the process of committing the crime. Is a suggestion that the police officer cannot arrest that member of parliament and must watch on for the crime to be committed whilst he writes to the speaker for his permission?
Absolutely not. It definitely doesn't make sense. So the police officer would have to arrest him because, and not just even the police officer, if it were ordinary people, they can also exercise the powers of citizen's arrest because there is a duty to prevent felony. If you see that somebody is committing an offense, yes, you can. Apart from the court, you can actually stop them under section 12, 13 of the Act 13. Citizens and citizens have the power to arrest the person committing an offense. And as for police, yes, they have powers to arrest. So once you see the offense being committed, you arrest. And then, if it happens that he was on his way from Parliament and all that, I'm sure subsequently the speaker will come in and they will look at issues of granting bail and all that. Yes.
Okay, so I asked that question because the police's side of this story with Sosu is they were at the ground of the protest and they actually saw that roads have been blocked, tires were being burnt in the middle of the road, and Sosu was the leader of the protest. And so at the ground, they attempted to effect his arrest together with others. Okay, his narration in Parliament was then he got into his car as the police attempted to arrest him. And of course, the constituents helped him and he was driven off. If the police had estimated that the blocking of the road during the protest and him leading it was in violation of the law, could they have arrested him last week, Monday, on the ground and still will be within the confines of the 117 article?
No, I'm not sure. It doesn't look like it, especially in the context of this Public Order Act. You see, so what the law is, and maybe we should be testing it, is that they are responsible. Let me see if I get my copy, so that the organizers or the leaders, and it's not just that, they say that so there's an option, ever. The first thing is that he says that the person who commits the offense, okay, he too can be arrested. And then the organizer, okay, so if you say you want to take the question is that is he just the organizer alone? That's one of the things that we should be looking at. We say, because the law foresees a situation where there will be the actual person committing, and even Evans said, that it says that when there is damage, it says when there is damage. So the first thing I'm looking for is that was he being arrested in respect of a damage? It says when there is a damage. Was it a damage?
Yeah, the police claim that there was destruction to public property. That's what they allege. And then there was the unlawful blockade of the road.
So where is that in there? So section 3 says, let's look at 3.1. Where at a special event, that's a demonstration, damage is caused to public property, the organizer or any other person found to have been responsible. Evans, have you seen?
Yeah.
Found to have been responsible. It's not saying that for the damage caused are liable, blah, blah, blah. Say the organizer or any other person found to have been responsible for the damage. So it's not clear to me that they say that if, let's say, a different person has committed, let's say, touch wood, Evans, when Council demonstrated, everybody to testify and destroy part of the road. It's not that clear to me that you, because of what you've done, then you hold honorable suit. It's not that language is not clear. Let's, for the avoidance of that, the other lawyers, maybe listen, let's look at it. It says, where as a special event, damage is caused to public property, the organizer or any other person found to have been responsible for the damage caused are liable to pay for the cost of the damage. So, Evan, when they if you look at it, they say pay for. So, if they say pay for, what's the thing about arresting the person? You say, it says pay for the damage. So, have you sent a bill to where they have not paid? Is that it? It says pay for. So, if I'm beginning to see that if you don't pay, then there are that's what we should be looking at the thing. Then let's go to the offense. When you look at the offense, fail to notify the police, that's section 9. Take part in a special event without the notification and all that. Evans, I think this is good is way you brought this, what you call it, this interview app. Yeah, I think we may find this, we may drive a coach through this law. So when you want to hold the organizer, it says pay for the damage. It's not that arresting. No. It doesn't say arresting. You should pay for the damage. So it means that the police should come up with a deal, and then you would look for the organizers and ask them to pay. If they don't pay, then you sue. Because apart from that, there's what do you call it? Offensive section 9. And when I look through section 9, I don't see anything about the damage. That because of the damage, then you go and act contrary to provision section 3. The person who acts. Yeah, it's not too clear. Evans, that's my. It's not too clear.
But very obviously, there's a lot there to still unpack as far as this is concerned. And Mr. Arigat, some have said, and very briefly, that the way to settle this is definitely go to the Supreme Court. You support the police's decision to take this up at the Apex Court?
So 117 is quite simple, and I don't think that it's complicated. I don't know why it's a matter that we have to go to the Supreme Court to resolve. But it's simple. It's a civil or criminal process coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to attending at or returning from any proceedings of Parliament. This is quite straightforward. So I don't know what it is about writing to the Speaker and the Speaker's response. It's clearly not within the ambit of the law.
Yeah.
Then the critical question is, was Sasu on his way to Parliament?
Well,
was he at Parliament?
It was a Monday.
Was he on his way back from Parliament?
Well, it was a Monday, and it was a Monday, and he says that he was on his way to a committee sitting, a committee, the ranking and deputy ranking members meeting, and that is why he made his way away from the ground.
The question is whether that meeting can be categorized as part of proceedings of Parliament. If your chairman calls a meeting of ranking members or whatever it is, or your caucus calls a meeting, that is technically not, in my opinion, proceedings of Parliament. Proceedings of Parliament is clear. For instance, if it is a committee meeting scheduled and captured in the business as part of the business of Parliament for a particular day, even if it is not in Parliament, if the committee is scheduled to meet at Alisa Hotel, and I'm on my way there, and it is captured on the order paper that my committee is meeting at Alisa Hotel. Even though I'm on my way to Alisa Hotel, I can say that I am attending to a proceeding of Parliament. If the committee is going to Cape Coast to inspect secondary schools and then to come back and write a report, and I'm actually driving to Cape Coast, I can claim that I was attending to a proceeding of Parliament.
Yeah.
So it's based on the fact. It's based on the fact.
That is actually a very interesting interpretation of this, which would disagree with the position as expressed by Mr. Susu himself in his statement today. But of course, we haven't seen the last of this because the police is still determined to push this through. We'll see how this plays out if he ends up at the Supreme Court. Thank you, gentlemen, for your time. Enjoy us again tomorrow.
But the question is, what is the police determined to do? Is it that they want to effect an arrest, or are they just inviting him to come and help them in an investigation? That is the question I want us to ask the police.
Yeah, I'm sure we'll get some clarity. And I'm grateful, Mr. Erga, for your time. I'm grateful, Mr. Su as well.